Well, with all the talk about our court systems, it's easy to forget the important role that our probate courts play in helping those with unique needs. So here to review some of the basics regarding guardianships and conservatorships is attorney Tom Sinas from Sinas Law Firm. Tom, first and foremost, let's talk about the basic difference between a guardian and a conservator and where these matters are addressed in our justice system.
Well, thanks, Derek. You're right. It is very easy to overlook the really important work that our probate courts do in our local community and around the state to deal with these matters of conservatorships and guardians. And that the probate court is the place where these matters are handled. So what are they? Well, the basic difference is that a conservator is someone who is appointed by the court, the probate court, to help someone who no longer or never did have the ability to take care of their own property. On the other hand, a guardian is someone also appointed by the probate court to help someone basically take care of themselves, to make the kind of decisions that they're no longer able to make in order to protect their basic needs. And for a guardian or a conservator to be appointed, the probate court judge has to first conclude that the person needs this particular service, and then has to determine who would be the appropriate person to act as either the conservator or a guardian. Now, you can imagine that in some cases, a particular person may need only a conservator or only a guardian, and then there are other cases where someone needs both someone to manage their assets and someone to make the decisions for their personal needs.
Let's talk about guardianships and conservatorship issues coming up in cases that involve personal injury.
Right, so this does happen, and it happens, I think, with more frequency than people would necessarily think. And how does it happen? Well, if someone has been involved in a serious injury case, that person may be in a situation because of their injuries where they are not able to make the kind of decisions that they need to make to pursue their claim. And so in that case, the probate court may appoint a guardian to act on behalf of the injured person. Conservatorships in personal injury cases most often come up when someone has assets that flow from a personal injury case, most commonly a settlement, that needs to be managed. And we see this very commonly in settlements involving minors. Of course, we don't give minors money from a personal injury settlement and just hand it over to them. We want to make sure that money is properly managed. And so a conservator is appointed to manage the assets of the settlement of a minor. And the same can also be true when you have assets going to someone who, because of their injury, are unable to handle their own assets.
Okay. Interesting stuff. How do people get more information if they need to track you down, Tom?
Well, they can find us online, www.sinusdramus.com. They can shoot us an email at info@sinusdramus.com or give us a call in West Michigan, 616-301-3333.
All right, Tom, thanks a lot.
Thanks, Derek.